You are a prophet again, because actually after last elections to European Parliament in Poland, already few academics, they said that there might be material to go to European courts. So already it's on the floor, and probably, no, for sure, in the future it's going to happen. Thank you so much. Do you have any questions, please, from the public? Okay, so let me up. Is there a microphone for Adam Bodnar? Okay. They're here in the front.
Thank you very much. I have a question to Professor Maduro and Professor De Wet. In fact, I wanted to say that I remember some time ago in Oxford, you inspired me to talk a lot about European Parliament elections in the context of free elections, and I didn't predict at that time that we'll basically get to this moment. And quite recently, together with John Morin, we have published an article in Politico about this. And I think your argument about making the case, the strategic case concerning election of some members of the parliament in unfair fashion is quite interesting one. But I have a question concerning the consequence of this judgment of the district court in Westfold, because we know that this case has it is the case concerning European arrest warrant, and it was in the presentation of Professor De Wet. The case went up to the Supreme Court of Norway. And do you think that in this context of this, let's say, interdependence and this search for some, let's say, new remedies to a situation, the Supreme Court of Norway may go further, or might be more, may go further than potentially Court of Justice of the European Union in saying that, sorry, we have to stop using European arrest warrant? Because maybe it seems that Norway might be in a little bit better position than the Court of Justice in just indicating this, because of course it is bound by the special agreement with the area of freedom of justice, but maybe it gives also a little bit more flexibility in terms of establishing new standards and sending a signal, a strong signal to Polish authorities in this regard. Thank you.
When Selmer came out, I wrote at the time that the courts of justice seemed actually to be asking national judges and national courts to help it support and protect the rule of law at the level of member states. Because Selmer was before the infringement decision against Poland, and to a certain extent it was easier if it was not the Court of Justice, the first one to say that there was an infringement, but it was actually the national court of another member state that will refuse recognizing or implementing a European arrest warrant from Poland, saying that there was no compliance with the standards. So it can play that role, and that's a positive role. The idea that the conflict does not become only one of the European Union versus a national sovereign state as Poland, but become other member states and judiciaries helping to put limits on the violations of the rule of law, in this case in Poland. So from that perspective, I think it's positive. But there is a risk too, because the criteria is really hard for national judges to apply. It can also be manipulated by national judges in the future to not be as mutually recognizing of other legal orders. So what we think they can now do with respect to Poland, it may be positive. It may turn in the future as a mechanism starting multiple conflicts between national legal orders. Since the criteria is very open and determined. And that might not be positive if in the end the application of EU law leads to conflicts between different national judiciaries. So there's an aspect where I can see that that can be positive, and certainly Norwegian Supreme Court may be in an easier position to do that. There is another dimension where I think there are risks involved in that. By the way, just to highlight another aspect, one of the tensions of this line of case law is that a condition for a court to be recognized as a tribunal for the purposes of submitting a reference to the Court of Justice is judicial independence. So if we wanted to be strict about it, the paradox is that the Court of Justice might have to declare inadmissible references from Polish courts that looking for the application of EU law, those more, let's say, the few or some that will remain friendly to the European legal order, by having to declare that they are not to be treated as tribunals anymore. That's one of the tensions in this area of the case law. I don't know how to solve. I think the court has ignored that problem so far, and rightly so. And in my view, it should continue to not pay attention to it. But if we wanted to be more formalist in that respect, that is a tension in the case law.
Professor De Wert.
Well, not an easy question. May the Supreme Court of Norway go further? Well, I suppose not as it stands in Selmer, to be honest. As I said in my talk, the decision is not even in the spirit of Selmer. I would hope that they first would refer the question to the Court of Justice. I'm not sure if there is any room for them different from us, although they are not a full member of the European Union, of course. It's interesting, by the way, that in its judgment, the Court of Norway refers to Article 6 of the Convention and not to Article 47 of the Charter. That was an interesting issue, to be honest. And if they go to the Court of Justice for a reference, I would like that they would also take into account in that reference the point that I tried to make today, is the one of damage control of national judges applying European law at this moment, because I think this is an issue that is really important. It's about the credibility of what national judges are doing and public opinion being criticizing national judges. So there is this is another aspect of the Selmer jurisprudence that is not very often being discussed, but it is being felt in the member states, I can tell you. So if that may be an answer, then I'm happy.
Yeah, and just referring to what you said, there is pending case actually now in European Court of Justice. The preliminary question was referred by member of the Supreme Court. We cannot call him judge, Mr. Zaradkiewicz, and actually it's still pending. So only opinion was released yet, and Advocate General Bobek, as I am correctly, I think, he said that it shouldn't be rejected on the basis that it's not independent court who issued the question, although he highlighted other issues and about independence of the European court. So that it's just, you know, now there's huge discussion, and it was discussion in Poland about this opinion, and we will see what European Court of Justice is going to do in this case. Is there any other question? There, right, okay.
Thank you, everybody, or the table for the excellent presentations that have been made this afternoon. I would like to ask the table if they think that things will come to a point where the independence of the constitutional courts of the national member states will be put into cause or put into issue. For if the European Court of Justice, as was referred by Miguel Boyage, could make a self-evaluation through 255 of the treaty, for there is an independent panel. There are many countries where constitutional courts do not even have an independent panel for the appointments to the Constitutional Court. And the Constitutional Court, as having powers to make preliminary requests to the Court of Justice, it would make sense then that the constitutional courts may be put also into question. That would make, I think, a European scandal. Although in the European Court of Human Rights, the constitutional courts of some of the participating members have been put into issue, as I suppose tomorrow will be talked about. So I'd like to ask this question, for if the interpretation of Article 19 is bold, and as Miguel showed brilliantly, that the interpretation of the Court of Justice cannot be otherwise, I ask you about the constitutional courts of the member states.
I can start, and I think that's why the Court of Justice places so much focus on taking into account all the circumstances. As I said, the court is careful enough to say that the simple fact that the appointment is done by a political authority in and of itself, it's not enough to determine that judicial independence is in question. And therefore says that we need to look at all the circumstances. And it is because the court knows that those kinds of questions might arise. Let me give you another example of how context matters. Orban in Hungary wanted to create a new jurisdiction, an administrative jurisdiction, and was saying, but what I'm doing is exactly what other countries, like for example in Portugal, we have, and other member states. So what's the problem with that? But everybody knew that the reason why they wanted to do it is to get an entire set of new judicial appointments to be done. And so that's why the court is so careful in not saying that a specific rule in and by itself determines a violation of judicial independence, but says that it needs to be placed in the context of the overall system and other mechanisms and safeguards that may exist. But that is also what makes it hard to develop this case law in any other way that is not a case-by-case basis, and it creates risks of numerous litigation being brought before the Court of Justice.
Well, I guess we should perhaps distinguish between the criteria for such a decision and that should take into account all the circumstances, and the question of whether the European Court of Justice has a basis to do it. That's my point. Miguel very boldly pointed the motives for this. My question was a little bit different, whether there was a basis in the treaty for this. But I recognize that it's a development that it's not to be undone, probably. Yes, I think as it stands now, the European Court of Justice could do it. The problem is whether the criteria which criteria would be applied. And as I see it, until now, these decisions are perfectly reasonable.
I think we are out of time, actually. I don't know, is there any other question? Maybe the last one? Okay. So thank you very much to all panelists and to the audience. Thank you so much. And the last announcement, we gather in the lobby at 7:30, right? 7:30, before going to the restaurant. Thank you.